The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save this state and this honorable court.
Good afternoon and welcome to this remote session of the North Carolina Court of Appeals. I'm Judge Richard Dietz, and joining me on the panel today are my colleagues Judge Hunter Murphy and Judge John Airwood. We have two companion cases on the calendar today, consolidated for a single hour of argument in 30-minute increments, and we'll begin with the first of those two appeals, number 21-262. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Thank you, Your Honors. May it please the Court, my name is Amy Savon, and I represent the plaintiff, Tara Dow-Rein, in these two matters. I'd like to reserve 3 minutes of rebuttal for this argument. This lawsuit is brought by Ms. Dow-Rein, a North Carolina resident, against multiple defendants when in her search in 2015 and 2016 for a suitable jumper show horse for her 11-year-old daughter, she connected with these defendants and both through their independent and joint actions was misled into purchasing two horses which ended up being unfit for her purposes and were in excess of their market value. The first horse, Season, was lame, and the second horse, Spread, had behavioral issues. The claims brought against the defendants were for unfair and deceptive trade practice, fraud, negligence, and breach of contract. The state of North Carolina has a manifest interest in addressing these injuries brought against its resident, Ms. Dow-Rein, and providing a convenient forum for her claims against these out-of-state actors. Her injuries occurred in North Carolina, where these horses did not perform as they were intended.
Now, Ms. Savon, she bought these horses, one in Florida and one in Virginia, and went to see them there. Is that correct?
That is correct. What she purchased them from a Florida salesperson and from a Virginia/Florida salesperson for the horse, and visited the horses at those locations.
And I want to make sure I'm clear a little bit on the facts with, I think, the horse Fred. Was it in Florida initially and then went to Virginia where she viewed him after this all started? And even if so, you haven't really made the animal passing through North Carolina part of your argument at all, correct?
So in this case against Fred, she first visited the horse in Maryland through the other defendant, Mr. Schaub, and then also visited the horse in Virginia. The defendant at issue, Miss Caluccio and Hidden Ridge, they are from Florida, but they have a farm in Virginia. But here, in regards to the Caluccio defendant specifically, there is jurisdiction in North Carolina over Allison Caluccio, Evan Caluccio, and Hidden Ridge because these defendants knowingly sold a horse to a North Carolina resident through her North Carolina agent, and significantly, to this case, guaranteed in writing how the horse would actually perform in Raleigh, North Carolina. And therefore, the trial court erred when it determined that there was a lack of jurisdiction over these Caluccio defendants. Of course, for jurisdictional issues, we're dealing with the landmark cases of International Shoe and Burger King. And significantly there, the Burger King case indicates you have to have purposeful availment, and the whole relationship should be reviewed, the before, the during, and the after, so to speak, and the actual relationship with these defendants. In regards to the quantity of contacts, the nature and quality of contacts, and the source and connection of the contacts, the interest of the foreign state, and the convenience of the parties, all of these show that there is jurisdiction over the Caluccio defendants in North Carolina. And significantly, in the Tom Talks case, our Supreme Court case did say that one contract can be sufficient enough for there to be personal jurisdiction. This case was before this court and it was remanded. That upon the court's remand, the trial court issued new orders, and in the new order determined that there was not jurisdiction over the collucio defendant. The other side believes that just because it was determined that the collucio defendant affidavits were credible, that this ends the analysis and therefore there's no jurisdiction. But this is not the case. Some of the statements in the affidavits are vague or beyond their personal knowledge or contain conclusions of law to which they cannot opine about. Further, there's statements in the affidavits that do not directly contradict the actual statements that the specific story that is explained in the complaint. And significantly, there's other evidence.
Ms. Savon, did your client submit any affidavits with respect to this?
My clients did not submit affidavits in this. They relied upon.
Did you object at the trial court level to any specific parts of the defendant's affidavits?
I don't think that any specific parts were objected to. It was more the fact that you can't rely upon all these conclusionary statements that are in there.
Did you point out to the judge in your argument that you couldn't rely upon any of those statements? Did you object to any of those statements or say any of them were incompetent evidence?
The statements at trial, it was pointed out that the collucio defendants, just their affidavits, what was in them in and of themselves couldn't be believed when there was additional evidence such that the bill of sale and the addendum in that bill of sale that needs to be looked at for the better offer of evidence, so to speak, of what was agreed upon with these parties. And I'd like to pull up that bill of sale. So this is the bill of sale between Dow-Rein and Hidden Ridge International, which is the farm owned by Ms. Collucio. And in this contract, it identifies that Hidden Ridge's address in Virginia and that the buyer is in North Carolina. And then significantly, as a way to induce Ms. Dow-Rein to go ahead with this purchase of this horse, there was an additional, in addition to this kind of generic bill of sale, there was an additional piece, this addendum. And this addendum is the most important contact here in this case, because in the addendum it says, as per my agreement, upon arrival at Paramount Show Stables at 3417 Oldmore Barney Road, Raleigh, North Carolina, opening night, aka Fred, will behave in the same manner as when he was ridden in Hidden Ridge, Virginia, and then goes on to discuss those qualities. It is this specific statement in this addendum, this warranty of how he would perform, which shows that the performance of this contract was in North Carolina. And it shows that there was a substantial connection to North Carolina. And it's this addendum that made the defendants be aware that they were making a purposeful availment to North Carolina and could be sued in North Carolina should this addendum, where they specifically pointed out how the horse was gonna behave in North Carolina. This is their purposeful availment, and it is this contact in particular which gives North Carolina jurisdiction over these defendants. In addition to this, it's not just this one contact. There were also the communications that the Collucio defendants had with Ms. Dow-Rein's agent, Ms. Sarle, who is also a Wake County resident. So you also have the communication in addition to this one very significant contact with the state of North Carolina, guaranteeing performance.
On those conversations, those communications, is there anywhere in the record that we have, besides what you're wanting to put in, that any of those communications were initiated by Ms. Cusciano versus initiated by Ms. Sarle?
With the evidence that the trial court reviewed, there's just the allegations in the complaint, just in general, talking about discussions that Ms. Sarle had with Ms. Coluccio, and nothing in particular stating when it was Ms. Coluccio who first reached out to Ms. Dow-Rein.
Okay,
Now,
and
is it
go,
is it your contention, you pulled up this bill of sale and it talked about that it would perform in Raleigh the same way it performed in Virginia, that Fred would. Is it your contention that if it had said that it would perform that way in any horse show in any jurisdiction, that any jurisdiction would have, that any state would have jurisdiction over it? This is a hypothetical I'm asking,
Right.
not.
Yes, Your Honor. That would depend on how it's actually worded, but potentially, if the buyer of the horse is saying in any jurisdiction, it's going to perform as it is in Virginia, that's certainly going to be a substantial contact for that state. Here, it's more critical because they also obviously knew that Miss Dow-Rein was from North Carolina, and it put in there the name of the stable where it was going to be residing in North Carolina. And then again, the communications that they had through Ms. Sarle discussing that. So it would certainly be a contact that would definitely be considered in the hypothetical that you mentioned. The weight, because if it was so broad, the weight of that, might shrink a little bit as compared to this case, but it still would be a contact to consider.
Counsel, you mentioned the evidence that was available, and so I think you're headed in a direction I want to take you there before your time runs out. But can you talk to us about your view of the mandate rule and what the trial court did in this case?
Yes, Your Honor, that is where I was going to head next. The remand in this case that this court gave indicated that the court needed to go back and make conclusions of law and findings of fact based on the evidence in the record. The issue is, when the parties went back, there was a disagreement over what that meant. We contend that in the record is just a general statement saying that anything that was put before, that the court wanted to allow to be put before it, that would be proper evidence that the court could consider, and trying to make this determination and making sure the determination, was correct upon considering all the evidence that was put before him. And so reviewing the Coluccio's own discovery responses, in addition to additional affidavits, that this would all be relevant information that the court, in its discretion, could review if it wanted. However, it's very clear from the order that the court thought that it was not allowed to make a determination about whether or not it wanted to review this additional information, and thought that it was stuck with whatever did come up here on appeal the first time. And so we think the criminal cases in particular are very clear that if this court wanted to limit a remand, then that remand has to be very specifically stated. And here it was not. And so therefore it would have been in the court's discretion to make a determination of accepting additional items for it to review and consider in making this determination about whether there is personal jurisdiction. And I do see I'm into my remand time, so I would like to stop now, if that's all right.
All right, thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. My name is Dan Gibson. I represent the Coluccio defendants, and I'll pick up where the appellant left off, which is the mandate question. Our argument is that when this court remanded this case in the first instance, and it instructed the trial court to make its findings based on appropriate evidence in the record, the only reasonable way to read that phrase and to give it any meaning is to say that that phrase limited what evidence the trial court could consider. If that phrase simply meant any competent evidence, then it would be requiring nothing more than what the rules of evidence and this court already requires the trial court to do. That phrase was not just precatory. This court chooses its words carefully and knows what it means when it chooses its words. When it says based on appropriate evidence in the record, it knows full well that the record that it is considering is the record at the North Carolina Court of Appeals. And there's a good reason to require that. All of the parties consented to a hearing on the defendant's motion to dismiss for lack of personal jurisdiction. None of the parties requested a motion to continue at the first hearing. None of the parties requested to present any additional evidence at the first hearing. We appealed from that first hearing, came to this court, and this court remanded because it faced issues with findings of fact that it could not make. So we remanded to the trial court to make additional findings of fact. Allowing additional evidence on remand would essentially allow the plaintiffs another bite at the apple after they had already consented to a hearing and had that hearing reversed on appeal. The key question here is a factual question. And that factual question when it comes to personal jurisdiction is whether or not the defendant reached out to North Carolina. Now, the appellant's brief says that whether the Coluccio defendants reached out to North Carolina is not the only factor in determining personal jurisdiction. But the North Carolina Supreme Court disagrees with that statement. The North Carolina Supreme Court in Mucha versus Wagner expressly held the plaintiff has the burden of proving that the defendant deliberately reached out beyond its home. The reason why that burden is on the plaintiff is because the plaintiff must show evidence that the defendant intentionally targeted the forum state. And that evidence has to come from the defendant's actions. The plaintiff cannot unilaterally create personal jurisdiction. You've heard a lot of arguments about the personal guarantee in the bill of sale, not the personal guarantee in the bill of sale, the guarantee in the bill of sale. And that the guarantee says that when the horse arrives in Raleigh, North Carolina, it will behave the same way that it behaved in Virginia. The bill of sale goes on to explain what that guarantee actually means. It says this includes him being, this warranty only covers suitability to be a children's hunter / junior hunter. So what this guarantee is saying is this horse will be fit for a child or a junior, and this horse will be quiet and honest and brave for a child or amateur rider. It's basically saying what you see is what you get. The connection to North Carolina there is incidental. North Carolina is just the place where this horse is being delivered. Essentially, what this guarantee boils down to is that the horse will be the same as what the defendants represented the horse to be. Now, we can argue about whether or not the horse factually was the same, but the question of what this contract means, where the contract was formed, and where the contract was performed, those are all questions of law for the trial court. And those are all questions of law that the trial court has already ruled on. And the trial court ruled on those based on the affidavits of Evan and Allison Coluccio. And those affidavits did say the contract was performed in Virginia, not North Carolina. The reason why they said that is money was exchanged in Virginia, and the plaintiffs came to Virginia to pick up the horse. The horse was not shipped by the defendants to North Carolina. That was one of the factors that this court specifically requested that the trial court look into. There were 3 of those factors: where the contract was formed, who shipped the horse, and what the defendants' contacts with North Carolina were. The trial court found the contract was formed in Virginia based on those affidavits. The trial court found that the plaintiffs had the horse shipped from Virginia to North Carolina, and that's uncontested. And they found the critical factor of who initiated the contact, and this is also undisputed. The plaintiffs initiated the contact here. The plaintiffs came from North Carolina, first to Maryland, then to Virginia. And the contact between the defendants and the plaintiffs was solely between the defendants and the plaintiff's agent. Now, the plaintiff's agent affidavit says, I was in North Carolina this entire time. Paramount Shoal Stables has a Facebook page that says it was in North Carolina, so you should have known that I was in North Carolina. That's the only evidence that the defendants had any reason to know that they were dealing with a North Carolina agent for this plaintiff.
Well, Mr. Gibson, we've got the addendum that clearly makes it clear that this animal is coming to North Carolina and it's expected to perform in some certain way in North Carolina. Why is that not a contemplated future consequence if it fails to perform under Burger King?
I think it may be a contemplated future consequence. I don't think that that is part of the performance of the contract. I think that what that is, and that doesn't also connect directly to North Carolina. The hypothetical that I believe I mentioned in my brief and I argued to the trial court was, imagine that the plaintiff moved and said, well, actually, I need you to ship the horse to Georgia. And then the plaintiff said, well, the horse wasn't, made all the same allegations, said the horse wasn't what you said the horse was going to be when I was in North Carolina. The defendant couldn't come along and say, well, my guarantee was only for North Carolina. This is a warranty of suitability for a particular purpose. It's the purpose that controls, not the location. And with respect to shipping this horse or having contact with the state of North Carolina by sending goods to a North Carolinian, which again, the defendants didn't ship this product to North Carolina. One of the cases I put in my memo of additional authority, Happy versus Valentine, I think is very instructive on this point. In that case, a North Carolinian came to a Vermont furniture store and ordered, I believe it was a cabinet from the Vermont furniture store, paid all the money for it there. The Vermont furniture store arranged to have that item shipped to North Carolina. Clearly knew this cabinet was going to North Carolina. The argument was that the cabinet was injured or was damaged during the shipping process, and that damage also injured the plaintiff. They were trying to sue in North Carolina, said, hey, you shipped the good to North Carolina. That means North Carolina has personal jurisdiction. The Happy Court said that wasn't good enough. That wasn't intentionally availing. That wasn't reaching out to North Carolina. And that's because really what we're looking at here is whether or not the defendant is the one initiating this contact, is the one reaching out to North Carolina. The plaintiff's argument, and you just heard it, is that if we guaranteed that this horse would perform suitably wherever you took it, then we would wherever she took it would have jurisdiction. That's not the law of personal jurisdiction. You can't just make a generalized statement that's diffuse. It's contacts with a particular person or with a particular horse are not the same as contacts with a particular forum. There has to be some sort of intentionally targeting North Carolina on the part of the defendants. It has to be the defendants saying, hey, North Carolina, we want to do business with you. And on that point, I'd like to address what I think is the appellant's strongest case, and that's Baker. This is a case where a boat was sold from a South Carolina boat merchant to a North Carolinian. That case is distinguishable. On its face, it looks like it may be somewhat similar to this. The plaintiff comes to a South Carolina boat seller. He says, hey, I don't have anything for you right now, but I'll start looking. Months go by. It was summer of 2014 when they first had contact. In fall of 2014, the defendant calls the plaintiff and says, hey, I've got just the boat for you. Check it out on my website and I'll ship it to you. And that's exactly what happens. The plaintiff goes online, sees this boat, and says, I want it. And the defendant ships it to North Carolina. And those two contacts were the contacts that specifically created personal jurisdiction in Baker. The first was the defendant intentionally calling someone in North Carolina and saying, I've got a boat I want to sell you. And the second was the defendant shipping the boat to North Carolina. Those two contacts were intentionally availing itself of the benefit of doing business in North Carolina. It wasn't just passively doing business with a North Carolinian reaching out to it. It was actively reaching out to a North Carolinian, trying to do business with a North Carolinian, putting its goods in commerce in North Carolina. Neither of those contacts are present here. The actions that you see are consistently the plaintiffs coming to Maryland, the plaintiffs coming to Virginia, the plaintiffs shipping the horse from Virginia to North Carolina. Sure, my clients knew that the horse would be used in North Carolina, but that does not create personal jurisdiction in North Carolina.
Mr. Gibson, do you have any case law? You know, we're kind of in a unique situation. We have a base contract and we kind of have this warranty. And to me, the North Carolina portion really comes into play with the warranty. Do you have any cases dealing specifically with warranties and where the courts have said there is or there's not personal jurisdiction based on potential violation of the warranty provision when the person knows it's going to be used in that state versus, you know, regular sales contract, you sell, it's done. But the warranty provision to me suggests that there's at least some different aspect and continuing relationship between the parties when there is a warranty, and especially here where it's indicated that it's going to be, that warranty could be violated in North Carolina.
I think that's an excellent question. 2 points on that. First, I would say this is a warranty for fitness for a particular purpose, and that purpose is really what matters here. Secondly, I've done a lot of research looking for a case directly on point on that warranty issue. I haven't found one. The closest that I found, and this is one that was already cited in the briefing, is the case of United Buying Group. In that case, it wasn't dealing with a warranty, it was dealing with a personal guarantee. So an out-of-state defendant personally guarantees a North Carolina contract. That court said that did not create personal jurisdiction because it wasn't, again, the defendant intentionally availing itself of the benefits of doing business in North Carolina. And I'd say it's pretty simple. If you affirmatively advertise or say, we guarantee this will be the best horse in North Carolina, or we guarantee you'll win this race in North Carolina. If you reach out to North Carolina in some way that intentionally targets North Carolina, or that warranty intentionally targets North Carolina, great, there's personal jurisdiction. But if all you're doing is saying, this horse is the horse that will do the job for you, it will be safe for your child, that is not intentionally reaching out to North Carolina. That is just saying, I promise you that I'm not lying about this horse, and when you get it back to wherever you're going with it, it will be the same horse that you saw here in Virginia. And it's important to note that that guarantee mentions both North Carolina and Virginia. It says the horse in Virginia will be the same as the horse in North Carolina. It's again, North Carolina reaching out to Virginia and Virginia saying, sure, we'll send you something and we'll guarantee that it's going to be a good horse.
Thank you.
I think it's also important to note here that the trial court did in fact consider some of the evidence that the appellant is saying would reverse and would change the trial court's decision. One of the trial court's findings of fact, and it's at record page 738, the Coluccio defendants were aware plaintiff was from North Carolina and would be taking Fred to North Carolina. Even with that finding of fact, the trial court concluded that North Carolina did not have personal jurisdiction. And it concluded that because of the simple reason that I've already laid out many a time here today, which is that the Coluccio defendants didn't intentionally reach out to North Carolina. Just knowing that you're doing business with a North Carolinian is not enough to create personal jurisdiction. You have to intentionally reach out to North Carolina, and there, the defendant here has not met its burden, or the plaintiff rather, has not met its burden of proving that the defendant deliberately reached out to North Carolina. And the most recent cases from the United States Supreme Court and from the North Carolina Supreme Court are the nail in the coffin of that argument. Thank you, Your Honors.
All right, thank you, counsel. Any rebuttal?
Yes, thank you, Your Honor. I'd like to address a few of the cases that were mentioned by Mr. Gibson. The Mooker versus Wagner case that very recently came out of our North Carolina Supreme Court is helpful actually to plaintiff's case here, because in that case, the North Carolina Supreme Court discusses a lot about the awareness factor. And obviously that has to go with something else, but it was very critical here. It's known that they weren't aware that Ms. Dow-Rein and her agent were from North Carolina. And the trial court did not have to look at additional evidence that was proposed to be submitted to that. That can be seen from the bill of sale and the warranty itself, that Ms. Dow-Rein was in North Carolina and that the horse was going to be used in North Carolina. But the Supreme Court indicated that this awareness of knowing where it is that your communications are going to, that can be very important. Additionally, the Baker case, the boat case, I do believe that case is, like Mr. Gibson says, similar here, and it's similar, obviously, in some ways and different in others. But that shows that when you're in the process of not just putting, an ordinary widget into the stream of commerce, but doing a substantial, significant sale and purchase here, that when you're having that communications, even if they're minimal communications with that buyer, knowing that that good you're selling is going to be used in North Carolina, that can be substantial. And the actual contacts here, the amount of them, even just going by what is in the complaint, are more than what is in the Baker versus Linear Marine.
And
case.
in Baker, did the defendant actually reach out and call or email to tell them, I've got this boat I want to sell you?
The first contact was by the plaintiff to the defendant, looking for their search for a boat. And then it is, from that case, it does indicate that the defendant then called back and said, oh, you know, I have a potential boat for you. So that certainly is a difference from what's at issue here. But when all the specific contacts here are reviewed, including that warranty, which is not in that Baker case, where the warranty itself is saying, here, I guarantee that when you take this horse to Raleigh, North Carolina, it is going to perform like it did in North Carolina. That is reaching out to North Carolina with purposeful availment, because that contract is being performed because of that specific warranty that was given in order to make the sale.
All right. Thank you, counsel.
Thank you.
We'll move on now to number 21-267, and we'll hear from the appellant.
Apologies. May it please the court. My name is David Early, and the camera's out of focus. There we go. My name is David Early, and I represent William Schaub and Over the Hill Farm, sometimes referred to as the Schaub defendants in this action. I reserve 3 minutes for rebuttal. The United States Constitution requires that there must be sufficient minimum contacts between a non-resident defendant and our state, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. Otherwise, the court lacks personal jurisdiction and the suit must be dismissed. The law is clear that the plaintiff must establish specific jurisdiction as to each cause of action, as shown by the Bristol-Myers Squibb and the North Carolina Mutual Life Insurance Company cases. Here it's clear that there are two separate transactions involving the sales of two horses. The first sale involved Season in December of 2015 by the Schaub defendants, and the second involved the Coluccio defendants and their owner, the Cokers, in November of 2016 in Virginia. And so I think given that, it's apparent that the court needs to examine each transaction separately rather than together, as to apply this sort of sliding scale personal jurisdiction test that I believe the trial court applied as indicated in my brief, and that the U.S. Supreme Court specifically prohibited in Bristol-Myers Squibb. So briefly, I want to talk about the second horse first, which is the one you've been discussing earlier with the other attorneys, which is Fred. If you go to the court's order denying the motion to dismiss of the Schaub defendants, which is on page 751 of the record on appeal in the Schaub case, and you look at the findings of fact there, it's apparent that the Schaub defendants had virtually no connection at all to North Carolina with respect to this sale. Looking at paragraph 11, Sarle again initiated contact with Schaub, a key factor, on behalf of plaintiff. Schaub was in Maryland for a horse show. Schaub knew about a horse named Fred and had it shipped by its Virginia owner to him in Maryland. Sarle and the plaintiff traveled from North Carolina to meet Schaub at an out-of-state farm where they saw and test drove Fred. And at that point, Mr. Schaub referred the plaintiff to the Coluccios to complete the sale and had no further involvement. There are no further findings of fact with respect to this issue. And since the court is plainly looking at the findings of fact with respect to Fred as to whether there is personal jurisdiction as to those claims involving Fred, I would submit that there clearly is not personal jurisdiction as to the claims involving Fred against the Schaub defendants. Given that, I'd like to spend the remainder of my time talking about the first transaction related to Season, which I think is a little more complicated, unless the court has any questions with respect to Fred. Okay, thank you. So here, the North Carolina Court of Appeals has already previously decided essentially this issue. when it decided the Hiwassee Stables case, which is remarkably similar to the case at hand here involving the sale of Season. And I want to go over the facts of Hiwassee Stables for a moment, just to show how close the parallels are. In that case, the plaintiffs were seeking to purchase a horse in order to breed that horse in North Carolina. And they apparently located a horse located in Florida, just like here. They were looking for a veterinarian to perform a breeding examination of that horse to make sure that it would perform as it could be expected and for insurance purposes. And they reached out to their insurance agent, who put them in touch with some veterinarians in Florida by the name of TVFA. The plaintiffs initiated contact with the veterinarians there. There's no suggestion the veterinarians advertised North Carolina or reached out to North Carolina. They reached an agreement on the veterinarians performing that examination. That examination was in fact performed. The veterinarians completed a form as requested by the plaintiffs and sent that form back to North Carolina. The plaintiffs paid the veterinarians out of a North Carolina bank account, and the check was cashed in Florida, and the examination was conducted in Florida. And the defendants, the veterinarians there, knew that the horse would be taken back to North Carolina. They knew that. Ultimately, the horse was in fact taken back to North Carolina, and the damages were allegedly suffered in North Carolina because the horse was not in fact suitable for breeding. This court held no personal jurisdiction, applying the five-factor test in Bank of America that this court required the trial court to apply in its first opinion in this case. And an important part of the Hiwassee Stables case is where the contract was formed. And you'll note that the opinion only notes that it says the parties contracted. It doesn't say where the contract was formed, whether it was a Florida contract, whether it was in North Carolina, who signed it first, whether it was oral. It doesn't go into any of that. I would submit that's because where the contract was formed was immaterial relative to the other facts in that case. Namely, the plaintiffs reached out to the defendants in Florida, and all the relevant actions occurred in Florida. The only connection to North Carolina was the knowledge that the horse would ultimately be in North Carolina, and that if there were any damages, those damages would be felt there. That, to me, is what makes Hiwassee Stables of particular relevance to this case here. And so now at this point, I want to turn back to what the trial court here did with its order denying the motion to dismiss. And if we turn to page 750 of the record, which is the findings of fact in the order denying the shop defendant's motion to dismiss, we see the facts that the court found with respect to the shop defendants and Season. So let's go through those. And as a reminder, this is what the Court of Appeals here is looking at to determine whether personal jurisdiction exists. So there's a lot of discussion about other facts and other issues and other evidence and all that type of thing. This is what the court is looking at and what the court should ultimately consider and whether there is personal jurisdiction. As this court astutely pointed out the first time, this court does not find facts. The lower court finds facts, and then this court applies those facts to whether there is personal jurisdiction based upon the appropriate standard, namely due process. And so looking back at paragraph 2 of findings of fact, on behalf of plaintiff, Sarle, Ms. Dow-Rein's trainer, initiated contact with defendant William Harold Schaub, a Florida resident, and his business, defendant W.H. Schaub Stables Incorporated, DBA Over the Hill Farm, a Florida corporation, for the purpose of the potential purchase of a hunter jumper show horse named Season. This is the key moment, in my opinion. As the other case law, the CFA medical case makes clear, who initiated contact is a critical factor, and the Hiwassee Stables Court also apparently thought that was the case. There's no dispute here that the plaintiffs initiated contact with the shop defendants, or there's no suggestion that the shop defendants advertised North Carolina or anything of that nature. Paragraph 3, plaintiff, her daughter, and Sarle traveled to Florida to evaluate Season, among other horses. They went to him. He didn't come to them. Paragraph 4, plaintiff purchased Season on December 22nd, 2015 for the purchase price of $120,000, which was wired to the shop defendants from plaintiff's North Carolina bank account. Fair enough, there is a North Carolina connection there, but as the Hiwassee Stables Court made clear, payment from North Carolina is not enough. It doesn't tip the scales. Paragraph 5, plaintiff's purchase of Season was memorialized by a bill of sale signed by plaintiff and shop. And as you know, we contest finding of fact 5, and I won't get into the details of that here. That's covered in our brief. But suffice it to say, I think the Hiwassee Stables case makes clear that where the contract was formed is not the key issue here. The key issue here is who initiated contact and what did the defendant do to avail themselves of conducting business in North Carolina. I mean, if Dow-Rein's argument were to be accepted here, her position is essentially that whether Mr. Schaub signed the contract before he emailed it to Ms. Dow-Rein, whether he signed it first or whether he signed it second, is the deciding factor here. That cannot be the law. The question is fairness and what he did to avail himself of the laws and benefits in North Carolina. Ms. Dow-Rein is the one who reached out to him. Whether he signed it first before he emailed it is irrelevant. And I would add.
So I didn't view that as the determinative fact finding for the trial court. And because if you look in the conclusions, we can get some insight into which of those findings the court ultimately found most relevant when, applying them to the law. And it seemed to be the fact that there was an instruction to pay money to purchase something into North Carolina that led to a payment from North Carolina out, and then a citation that implying that one of our cases held that alone, constitutes specific jurisdiction. So my question to you would be, do you agree that's an accurate statement of the law? And if not, why not?
To make sure I understand your question, the question is whether the payment from North Carolina to Florida is sufficient to result in personal jurisdiction in North Carolina. Is that the question?
Right. So it's conclusion of law 3, where the trial court,
yes, sir,
cites the Cherry, Becker, and Holland v. Brown case and says that this court has held that when one person directs money to be paid for something from another state, that can create personal jurisdiction, specific jurisdiction from the state where the money's coming from. And my question to you is that, and that seems to me to be looking through the findings, the critical finding the court was relying on to determine personal jurisdiction. I'm just asking you if you agree with that.
Respectfully, Your Honor, I would not agree with that. I think paragraph 3 deals with the North Carolina long arm statute, which is not at issue here. We don't contest the long arm statute. It's that the question is whether the due process clause is met. And there, the applicable test is the Bank of America case that the court referred to in its first opinion. If anything, I would say it would be and again, I don't agree with this, but the trial court's order was based upon paragraphs 5A to C that would supposedly distinguish it from Wassey Stables.
Okay, so that was my question. So you think the only time that it's looking at sort of a minimum contact specific jurisdiction analysis is distinguishing a case, that's that final sentence of paragraph 3, you don't think was transitioning from the first case saying this is the long arm statute, and then the second case saying, and this is where we think we're now in due process, and this is what we think. You don't think that's what the court was doing? Well,
certainly a payment from North Carolina is a factor. Don't get me wrong on that point. Did you hear that? Sorry, it wasn't clear. Certainly a payment from North Carolina is a factor, but it's not enough. It's a multi-factor test here, Your Honor, as evidenced by the Wassey Staples case. It's not just one touching on the state at all. It's a multi-factor test. And really quick at the end here, final findings of fact, paragraph 7, plaintiff took possession of season in Florida. Paragraph 8, plaintiff arranged to ship season from Florida to North Carolina. Defendants didn't ship it to North Carolina. They did nothing of the sort. And I'd add, the bill of sale here actually says the horse is being sold as is, no warranties. There's no warranty issue here. And then additionally, the bill of sale itself notes that this agreement shall be governed by the laws of the state of Florida. And as the court explained in the Tahal Bias case in 2004, that is also a factor, though of course not determinative. And therefore, Your Honors, in light of all the factors here, it's clear that there is no personal jurisdiction with respect to the sale of season either. And therefore, I request that the court dismiss the claims against the Shaw defendants with respect to season and Fred. Thank you. I'll reserve the remainder of my time.
All right. Thank you, counsel. We'll hear from the appellee.
Thank you, Your Honors. This lawsuit is not about two separate sales transactions. This lawsuit is about a North Carolina resident's search to find a suitable horse for her daughter to use as a hunter-jumper show horse. And the Shaw defendants were instrumental in the purchase of both horses here and developed an ongoing business relationship with her and cultivated that relationship, which is what gives this court jurisdiction over the Shaw defendants. So here what's at issue is the ongoing relationship during this 2015-16 time period, which is a fairly short period of time. And it's in regards to all of these actions during this period of time and how the plaintiff and her agent relied on the statements of Shaw based on the relationship they had that induced her to purchase both of these horses that are at issue. And what has to have due process here is for all of the claims that are brought by Ms. Dow-Rein to have a connection to have personal jurisdiction over these defendants for North Carolina. And that is done here. And it's not looked at as two separate sales transactions. It's regard to the activities of the defendants and whether they relate to each independent action asserted by the plaintiffs. And here they do.
I think that's a good argument for a specific jurisdiction. If you look at some of our case law we've actually already discussed today, which is this idea that if you're cultivating a relationship as a salesperson trying to sell something to someone in another state, that can lead to personal jurisdiction over that sale, even if you didn't go and complete the sale and deliver the product yourself into the forum state. So although that's a good argument, I don't see the findings the trial court made talking about that kind of cultivating relationship. So where are the findings that kind of spell that story out?
Yes. So, and I'll just refer you guys while we're talking about the ongoing business relationship and that being acceptable for finding specific jurisdiction. The North Carolina Supreme Court's Beam USA case is a different context, but they certainly talk about this ongoing relationship, and coincidentally, it's the same 2015-16 time period in that case. But to answer your question, Judge Dietz, in the findings of fact, the findings of fact, the ones just talking about the sale of shop, those would be part of the business, the relationship. And then looking at paragraphs 9 and 10 and 11, all talk about how Shaw provided other services for Dow-Rein in regards to servicing another horse, Bo, and the invoices and credit card information that bounce back and forth between them. Those are other contacts with North Carolina and with Ms. Shaw and Ms. Dow-Rein and Ms. Sarle. And then the whole introduction, all of this background information of their relationship referred them to the Coluccio's horse, Fred. It was Shaw that suggested that horse be viewed, and then actually took some time himself to introduce that horse to them in Maryland. So it's this business relationship they had and him trying to cultivate this relationship with this person who's known for being in the horse world, that all combined in this short time period is kind of how one event led to another. Because season didn't work out, that led to the search for Fred, and it's because of the additional services provided to Bo that they knew of this person who might have other interests. But specifically,
I guess the question
did was
what I was getting at is, so when you took the facts you described, the ones the court found that are in the order, then you're making this next step, which is saying, and that's part of cultivating this relationship. And then we get to, and there is case law that says that type of activity can lead to specific jurisdiction. But the question I have for you is, can we make that middle step ourselves? Because those seems like fact questions. What were you doing? Were you cultivating a relationship, or were these a series of isolated acts? And because they're just tangential, they're not directly related to these sales. That we can't say they were cultivating a relationship. They were just some kind. This isn't general jurisdiction. We're talking specific jurisdiction. So, that's my question: is are we missing findings here that would allow us to say, we get to the case law that you've been describing?
I don't think so, Your Honor. Those findings, those specific findings of facts are very specific. You know, this happened with Bo, this happened with Fred, this happened with Season. But what the court does in its conclusion of law 5A is it says the Schaub defendants were engaged in an ongoing business relationship with plaintiff during which the Schaub defendants provided services related to 3 different horses purchased and or owned by plaintiff, namely Season, Bo, and Fred. And so the court makes that connection there in that paragraph of how this ongoing relationship, bringing all 3 of these horses together and the various contacts that were within those, that is what the Schaub defendants were doing to purposefully avail themselves to North Carolina through their interactions with this North Carolina resident.
But let me ask this, even if we could consider that conclusion of law to kind of get to that cultivation fact, does 5A suggest that defendants were the ones pushing that or cultivating that, other than just a recognition of the existence of a relationship? Or is there a way to pull in those other findings of fact to say that this is the Schaub defendants cultivating versus just recognizing the relationship existed?
I think just recognizing the relationship existed and him it indicates in the complaint, which is not contradicted by the affidavit of Mr. Schaub, it indicates in the complaint that how he was working to lease this other horse for Miss Dow-Rein, this Bo horse. And so the statements itself, just recognizing the ongoing business relationship and then concluding it was an ongoing business relationship. You know, business is generally seen as something that's positive that you want to have happening, and there's certainly nothing saying, you know, anything contrary. So I do think that it's sufficient the way it is laid out in this order to get that there is this ongoing business relationship. That is going to be positive for the Schaub defendant. Yes.
Yeah, I think what Judge Murphy was getting at it, though, is that if the buyer or prospective buyer is the one that keeps reaching out and the relationship is forming because this person really wants something from the sellers, and is all sorts of things are happening because the buyer keeps reaching out and this is done, this gets done, and this gets done, and this gets done, that wouldn't necessarily lead to specific jurisdiction, because again, if what we're looking at is, are you coming to the form state, you know, to do these things? And if the buyer in the form state is reaching out to you in your home state to do all these things, it seems like a different scenario. So I think that's what we're getting at is, do we have here enough in these findings to say we can see this act of availing themselves of North Carolina through building the relationship?
Right. And so the contacts that went back and forth with all of those, just the amount of them as part of what we obviously look at for quantity of contacts with North Carolina. So that's part of that. And then in regards to Fred specifically, Schaub didn't just say, oh, I hear there might be a horse that the Colicchio defendants have. You might want to have your agent contact them. Instead, he specifically arranged, and this is alleged in the complaint and in his own affidavit, he specifically had this worked out so that he had the horse shipped to him in Maryland for them to come look at. So you can see by the allegations of the complaint that is him doing more than just answering a call.
But wasn't this after your agent reached out to him to ask about another horse?
Yes, it was her agent Sarle who did reach out to Schaub. But what I'm saying is what's in both his affidavit and the complaint is
did she not?
I'm sorry, what?
I'm sorry I interrupted you. She's reaching out to him on each of these sales, and on each of these occasions, your agent reached out to him initially. Isn't that correct?
That is correct, as far as the initial contact each time. But yet he responds back in multiple ways. But to your question, it is her that's reaching out each time. But
so how does that constitute, if your agent is reaching out each time, how does that constitute cultivating a relationship or cultivating business? to get you to the line of cases you want us to apply.
Right. So the important point is that this initiation is certainly a factor to consider in determining whether somebody has purposefully availed themselves, but that's not the only factor. Again, the Burger King talks about the course of dealing and, you know, what happens before, during, and after. And so if you're looking at the whole timeline of that, then you're not just looking at who made the initial contact. It's what keeps going on between them. And here there's, again, the invoices that go back and forth. Again, she was the last one who signed the contract, which indicates that it would be a North Carolina contract. And the payment going from North Carolina, again, just all of these add up to make it such, especially during this whole period of time where there's multiple interactions, that's enough for purposefully availing these defendants to the state of North Carolina.
Ms. Savone, I hate to keep circling back to this, but I think it's pretty crucial to our role in reviewing this case. You're referring at times to parts of the complaint that were not contested. And it's clear, you know, the trial court considered the affidavits. But the trial court still only made these findings numbers 1 through 15. And even if we pull in some of the conclusions of the law, is there part of these findings that suggest or say clearly that the trial court is finding as fact those allegations, uncontested as they may be, allegations in the verified complaint as being fact here, other than it being in the background, it being in what the court considered? I just don't see how those additional uncontested arguments and statements of fact in your verified complaint make it into these findings of fact and therefore make it into what we're reviewing to review the conclusions of law.
Right. So the court does indicate that he considered those, but as far as what specifically is in the order, it does indicate that the purchase price was sent from North Carolina, and it indicates the executed bill of sale was sent from North Carolina. And then it indicates, as we talked about, the ongoing relationship with Bo and how there were invoices sent back and forth and the credit card information. And the entire time, Schaub knowing that he was selling, again, this, it's not just a widget we're talking about here. This is a substantial purchase of this horse, knowing that she was from North Carolina and that the horse was going to be used from North Carolina. That's not contested. She did view the horse in another state, and that's part of the findings here. But the findings of fact are supportive of this enough to be purposeful availment, like in the Baker case regarding the boat that we talked about earlier. So I do think that this finding of fact, the 5A, just being engaged in an ongoing business relationship, that is sufficiently supported by what findings were made here by the trial court. And it talks about mailing multiple documents to plaintiff, that the form selection clause is not to be given effect because of the bill of sale being void, because he didn't actually hold title to the horse at the time that Ms. Dow-Rein signed the contract. So there is enough in both the findings of fact and the conclusions of law for this court to approve and to affirm the trial court finding of jurisdiction over the Schaub defendant. Here, as I've mentioned, it's this ongoing relationship. It's not just a one-time sales transaction, sold the boat and then done. That's what happened in the Baker case. Here, there was the sale of the first horse, and then there were the continued services provided, and then there was the introduction to this other horse, which Schaub also gave his own representations regarding how he believed the horse to be in regards to whether that horse should be purchased. So here there are sufficient findings of fact that are supported by what was before the court that show that jurisdiction is appropriate for these shop defendants in North Carolina. And again, here it's this North Carolina resident trying to, needing to have a forum to seek to have this lawsuit about her search be addressed. And this forum regarding all the different interactions is the convenient forum for this matter. Thank you.
All right, thank you, counsel. Any rebuttal?
Yes, Your Honor. Your Honor, this court was right the first time it said in its first opinion in this matter that this court cannot find facts. Here, the trial court has found the facts, and this court must apply those facts to determine whether there is personal jurisdiction. And I would add, we don't waive our contesting of some of those issues in there, but ultimately the question is applying those findings of fact in the trial court order, and only those findings of fact. Is there sufficient evidence to show a purposeful availment to justify the exercise of specific jurisdiction? I think I've made clear in my argument today, I don't believe that there is. There are not findings of fact showing this cultivation of a relationship between the shop defendants and Ms. Dow-Rein. As is clear from the findings of fact, which are uncontested, Ms. Dow-Rein initiated contact every time. It was not that Mr. Schaub called Ms. Dow-Rein and said, hey, there's this other horse that you might be interested in. It was always Ms. Dow-Rein who came to the shop defendants. And that is a critical factor, as said in CFA Medical. There's been no advertising or any pre-existing relationship in North Carolina that the shop defendants had. Again, it was totally on her own, but she came to him in Florida. And so this is a Florida case that should be decided in Florida, not North Carolina. And so to finally circle back, Pelosi Stables decides this case. It's clear that court applied factors, the correct factors, and it applied virtually the same facts as the facts that exist here. Plaintiff initiated contact. The work was performed in Florida. Yeah, there was a payment from a North Carolina bank account. That's not enough. The damages were ultimately felt here. It was known that if there were damages, they would be felt here. Again, that's not enough. I mean, if that were the case, then we would almost virtually never even have specific jurisdiction analysis where someone purchases something and then takes it back to their home. Clearly, those factors are not what matter. What matter is the initiation and where the contract was performed. Here, plaintiff initiated with the shop defendants. Shop defendants performed in Florida, and then later, with respect to Fred, Dow-Rein initiated with respect to finding that second horse, and Mr. Schaub didn't even sell the second horse to Ms. Dow-Rein. He essentially turned it over to the Coluccio defendants, and clearly there's no specific jurisdiction as to that transaction either. For those reasons, Your Honors, I would request that this court reverse the trial court with instructions to dismiss this matter for lack of personal jurisdiction. Thank you.
All right, thank you, counsel. That concludes the arguments. We'll adjourn.
This session of the North Carolina Court of Appeals is adjourned.
All right, thank you.